हाँ भाई, तो लास्ट क्लास में अपन ने रिट पिटीशन डिस्कस कर रहे थे. We have discussed about the various writs of habeas corpus, writs of mandamus. Now we are going to discuss about the another writs which has been left. So basically we have already discussed what is the difference between Supreme Court and High Court writ. Basically, Supreme Court writ is uh, coming under the Article 32 of the Constitution of India, which itself a fundamental right. But High Court writ is coming from the Article 226. So whether to issue the writ petition, whether to issue the writ or not to issue is totally dependent on the choice of High Court, but not in the case of Supreme Court. Supreme Court is mandatory to issue the writ on the violation of fundamental right, but it is not in the case of Article 226 because it's not mentioned in under Part 3, that is fundamental right. And we have already discussed high court have to issue the writs on their jurisdiction region. Basically that's mean, let us suppose UP High Court cannot issue the writ on the another state, and basically UP High Court can issue the writ in their own jurisdiction, not in the other's jurisdiction. But in the case of Supreme Court can issue the writ for all across the India. That is the second difference we have already discussed. Now, the third difference is that High Court have the power to issue the writ on violation of fundamental right, but have also power to issue it from violation of any other's right. But in the case of Supreme Court can issue the writ only on the violation of fundamental right. That is the basically difference between the Supreme Court and High Court. Now, we have also discussed that Parliament under Article 32 Clause 3, Parliament can also authorize to lower court to issue the writs. Basically, now only Supreme Court and High Court have the power to issue the writ. But if Parliament want, they can authorize to the lower judiciary by law to issue the writ petition. So that is the basically mentioned in under Article 32 Clause 3 of the Constitution of India. Now we are going to discuss various writs. So I have already discussed about the writ of habeas corpus, writ of mandamus, writ of quo warranto, and writ of prohibition. Writ of quo warranto, writ of prohibition, and writ of certiorari. So these are the basically five writs which can be issued by the Supreme Court and the High Court under Article 32 of the Constitution of India and Article 226 of the Constitution of India. Now let us discuss one by one in detail. What do we mean by habeas corpus? So basically mean what do we mean? Basically what is the mean? So habeas corpus means present the body. Present the body. So basically, if any person has been illegal detained by any authority, by any person, then if aggrieved party approached to Supreme Court and prima facie proved that their fundamental right has been violated, their illegal detention has been happened, then Supreme Court will issue the writ of habeas corpus to present that person before the court. So basically, it means if illegal detention has been happened, then if illegal detention by any authority or by any individual, if illegal detention of any person by any authority or by any person, then Supreme Court or High Court will issue writ to that authority to present that person before the court, to present that person before. If detention is not illegal, if detention not illegal, then okay, no problem. If illegal detention, then release him immediately. Now, so that is the basically habeas corpus is in under this. Supreme Court, High Court will issue the writ on illegal illegal detention has been happened of any individual by any authority or by any individual. So now there is a one concept that is principle of locus standi. What is the principle of locus standi? Basically means only aggrieved party can approach the Supreme Court on the violation of fundamental right. बेसिकली मीन्स आपका अगर फंडामेंटल राइट वायलेट हुआ है तो आपको ही सुप्रीम कोर्ट पहुंचना है, आपके बिहाफ पे कोई दूसरा नहीं पहुंच सकता। लेकिन इस केस में प्रिंसिपल ऑफ लोकस स्टेंडाई नहीं एप्लीकेबल होती। बेसिकली अदर्स कैन आल्सो अप्रोच द सुप्रीम कोर्ट ऑन द वायलेशन ऑफ अदर्स फंडामेंटल राइट। बेसिकली दैट मीन्स if any relative or any person has been illegal detained by any authority, by any person, then you can approach the Supreme Court and file the petition that illegal detention has been happened of my relative. Then Supreme Court will issue the writ of the habeas corpus and summon to that authority to or to person to present that person before the court. If it is not illegal detention, then it is okay. But if it is illegal detention, then release it immediately. It will applies to all authority, it will applies to all the individual, it applies to all the department, whether it will be police department। ऐसा होता है कि पुलिस जो है किसी व्यक्ति को डिटेन कर लेती है और जुडिशियल मजिस्ट्रेट के सामने प्रेजेंट ही नहीं करती है। उसके लिए ये एक रेट थोड़ी सी ठीक ठाक है। क्यों? क्योंकि ठीक ठाक इन द सेंस ये है कि भाई आप उसको मजिस्ट्रेट के सामने प्रेजेंट नहीं कर रहे हैं तो दूसरा व्यक्ति जाके हाई कोर्ट में पिटीशन फाइल करेगा, रिट पिटीशन, कि भाई रिट पिटीशन के तहत इस व्यक्ति को रिलीज करो। अगर इस व्यक्ति को रिलीज करो तो क्योंकि ये इलीगल डिटेंड हुआ है, आपने इसको 24 घंटे की जो लिमिट होती है उससे ज्यादा आपने इसको अपने पास रखा है, दैट्स मीन यू आर इलीगल डिटेन दैट पर्सन, then high court will issue the habeas corpus writ. So that is the basically writ of habeas corpus. Now let us discuss on the writ of mandamus. What do we mean by writ of mandamus? Basically, what the mean of mandamus? So mandamus means basically we command. When it is issued when by non performing any authority their work, your fundamental right gets violated। कि भाई कोई भी एक अथॉरिटी है जो कि पब्लिक अथॉरिटी है, एनी पब्लिक अथॉरिटी when by non-performing any public authority their work, your fundamental rights has gets violated, then you can approach the Supreme Court or the High Court. Then Supreme Court or High Court will issue writ of mandamus to advise to order them to perform their work correctly. But Supreme Court also stated that petition can writ of mandamus can be filed only one case. What is that case? Basically means you should go. ऐसा नहीं होना चाहिए कि आप उस अथॉरिटी के पास गए ही नहीं और सीधा आप सुप्रीम कोर्ट चले गए, नहीं। आप उस अथॉरिटी के पास गए हो, उस अथॉरिटी ने आपने उस अथॉरिटी से डिमांड की हो, और उस अथॉरिटी ने उस डिमांड को रिजेक्ट कर दिया हो, सो बेसिकली इट कैन बी इशूड, इट कैन बी एक्सेप्टेड बाय, सो it can be issued only if demand by party and rejection by authority has been happened, and after because of has happened, and because of rejection, because of it, your fundamental right gets violated. So that is the basically writ of mandamus. But remember one thing, it this writ has been issued generally to the executive authority, कि भाई कोई भी एक एग्जीक्यूटिव अथॉरिटी है जो कि अपना वर्क कायदे से परफॉर्म नहीं कर रही है, और उसके परफॉर्म ना करने से हमारा फंडामेंटल राइट वायलेट हो रहा है, जैसे कि मिनिस्ट्री, होम मिनिस्ट्री या सेंट्रल मिनिस्ट्री या कोई भी मिनिस्ट्री है जो अपना वर्क परफॉर्म नहीं कर रही है, या डिस्ट्रिक्ट मजिस्ट्रेट, या मतलब नीचे से लेके ऊपर तक, मिनिस्टेरियल हो, मिनिस्ट्री हो, भाई मिनिस्ट्री भी तो एग्जीक्यूटिव अथॉरिटी है, तो मिनिस्ट्री हो, कोई भी मिनिस्ट्री हो, ऊपर से लेकर नीचे तक, मतलब यहाँ तक जो गांव में खेत नापने वाला भी होता है ना, उसको क्या बोलते हैं, लेखपाल। तो अगर वो लेखपाल भी अपना काम नहीं कायदे से कर रहा है तब भी सुप्रीम कोर्ट इट इशू कर सकती है, और अगर मिनिस्ट्री भी अपना काम कायदे से नहीं परफॉर्म कर रही है तब भी सुप्रीम कोर्ट मैंडेमस की रिट इशू कर सकती है। अब ये रिट तभी इशू हो सकती है जब, अब ये रिट सभी एग्जीक्यूटिव अथॉरिटी के लिए इशू होगी, लेकिन इसमें तीन लोग इंडिपेंडेंट हैं, उन तीन लोगों के अगेंस्ट सुप्रीम कोर्ट रिट इशू नहीं कर सकती। वो कौन तीन लोग हैं? सो बेसिकली दीज आर persons, this writ cannot be issued against, cannot issue against, first president, second governor, third legislature. It may be state legislature, it may be union legislature. So this writ cannot be issued against the president, against the governor, against the parliament, against the state legislature if they are not performing their work. So that is the basically writ of mandamus. Now let us discuss about the writ of quo warranto. We have already discussed, I think. If not, then we will discussing right now. Now, so what do we mean by writ of quo warranto? Quo warranto means where is your appointment? Where is your appointment? So basically, if there is any person who has illegally authorized any authority, then, or the public authority, then Supreme Court or High Court will issue that where is your warrant, where is your warrant of appointment, on which behalf are you authorizing that authority. If warrant cannot be submitted by that individual, then Supreme Court and High Court can deny that, must deny that person to remove or to release that authority from their control. So basically, it is issued by the court to examine